Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today, IP pitfalls in data monetization. We're going to talk about the unseen value of data, the difficulties that exist with protecting data as traditional intellectual property, and the paramount importance of the contracting regime that applies with any third parties that are providing or obtaining data. I'm your host, Julian Dibbell. I am a senior associate in Mayor Brown's technology transactions practice. I'm joined today by my colleagues Oliver Yaros, a partner in our technology transactions practice based in London, and Rich Assmus, a partner in our intellectual property practice in Chicago. Rich, let me start with you. We hear a lot about the value of data. How much of that is hype and how much is real?
Thanks, Julian, and hello, everyone. It's true that there's a lot of hype about the value of data, but underlying all that hyperbole is some actual value, and it can take a couple forms. One of those forms is with respect to machine learning. With advances in machine learning algorithms, data can be the source of training for those algorithms, and that type of training data is really increasing in value. And that training data can be really any form of large data set. We wanted to give you a couple examples based on recent engagements. One example would be insurance underwriting files. So fairly unstructured data that an insurance company or an underwriter might maintain with respect to insurance policies that they've underwritten. Another example is short news reports on sporting events. Tagged image files are another big example of valuable training data. For example, the images might tell you something about the data, like, for example, whether or not it includes a parking lot in a view of a landscape, or how many stories a building has, something like that. Another example of data is machine data from electronic engine control unit. So as you probably know, your car and other commercial vehicles have computers in them that are gathering all kinds of data about engine performance. That data is voluminous and can be important training data. And even older data that has lost commercial sensitivity because of its age can have value as a training data set. In addition, as new advancements are made in machine learning and other technological improvements are made in that area, existing data sources can take on new value. So for example, a data set that was really of no particular commercial value, either based on its age or the nature of the data, might all of a sudden, based on advancements in machine learning, take on some value. In addition, given the ubiquity today of data collection devices, whether that's cameras, smartphones, or other connected devices, there's new data value being unlocked every day.
Okay, so it's really kind of the intersection of ways to collect vast new amounts of data and the growing importance of machine learning and other artificial intelligence techniques. So that's the recipe for value. We know data has value. How can a business protect that extremely important, valuable data?
So data is a frustrating topic for intellectual property lawyers because none of today's intellectual property laws were really written with today's data in mind. And it's frustrating because there aren't good answers as to how to protect it. If you asked me, how do I protect a better mousetrap, the answer is you patent it. If you ask me, how do you protect my new product name, you trademark it. If you ask me how you protect your new piece of software, I'd say you'd copyright it, but I don't have a great answer for how you protect data. It's in some ways a unique case. And what's, I think, particularly frustrating is that it's a significant driver of business investment. Companies are investing a lot in managing their data sources, analyzing their data sources, and so on. But although we can nibble around the edges of protection, there just isn't a great way to protect it under US intellectual property law. And sort of let me go through briefly why that's the case. So copyright does technically extend to data compilations, but the protection there is just for the selection and arrangement of the data, not the data itself. It's really a fundamental axiom of US copyright law, which I think is fairly consistent across the world, is that copyright never protects facts. And these data points are ultimately facts. So while you may have innovative database structures that could be subject to copyright protection, for many data sets that are valuable, that's just not true. So for example, a tagged image file is really breaking no new ground technically in terms of the selection arrangement of the data, but might be very valuable for machine learning purposes. Just as another example, a collection of electronic medical records really might break no new ground with respect to the structure or arrangement of that database, but might have tremendous value for machine learning purposes. So the bottom line of that is that copyright really doesn't help very much. Now, patent protection can protect certain novel data processing methods. If there were devices involved in the data collection, it might be able to protect that. Some overall system of data analysis might be protectable, but really none of that will protect the data itself. Moreover, the patent bargain, so to speak, is that you must make a public disclosure of your invention, and that can be inconsistent with data monetization strategies. So where does that leave us? That really leaves us only with trade secret protection as a last resort in terms of protecting data.
Okay, and so that's the, to be clear, the perspective of U.S. intellectual property law on data. Oliver, is the situation any different in Europe?
Thanks, Julian. It's quite similar. I mean, I would say trade secrets does exist as a concept in Europe. It is primarily protected by the rights that people have in the rights of confidence, so that information is considered to be confidential information belonging to the person who disclosed it. But the tricky thing is demonstrating that there is real value in the trade secret that is being misused. That is where the real challenge is, and it's quite often quite difficult for people in Europe to be able to establish that the breach of trade secrets has actually occurred.
And Rich, from your perspective, what are the key elements of protecting data as a trade secret?
So under US law, the heart of trade secret protection is the efforts that a company makes to keep that information secret. Under both state trade secret laws as well as the federal Defend Trade Secrets Act, a key element is reasonable measures to keep the information secret. And what that does is it puts a lot of pressure on in-house legal departments, which need to have the right policies in place on security, and they need to make sure that the confidentiality provisions with third parties that might access that data are robust and defensible.
Okay, so we're talking now about confidentiality provisions, contractual arrangements. Let's drill down on the topic of contracts a bit. So in the contracts where data monetization, protecting valuable data is at issue, what are some of the typical counterparties here?
Right. So it's important to remember that any counterparty that has access to the trade secret data or the data that you would like to protect as a trade secret needs to be bound by clear confidentiality rules. So in-house departments really need to think about every party that touches that data, because the analogy maybe is that your trade secret is only as strong as the weakest link in your chain of protection. So if you have 10 counterparties that have access to the data, 9 of which have very strong confidentiality provisions, but one of which is going naked in that regard, really that's going to be a problem for you proving up that you've taken reasonable measures to protect that trade secret. So really every counterparty that touches the data, has access to the data, needs to be subject to a written confidentiality agreement. However, we do see counterparties that come up again and again in these types of matters that you really want to pay particular attention to. So the first of those buckets of third parties are data vendors that you might be gathering data from. And it's important to state clearly what rights might exist in derivative data on that data. So for example, you might have a vendor that's providing you data that contains personal information. What rights do you have to analyze that data on an anonymized basis? You want to make sure that that data is yours to use in that fashion. Clients might also have vendors that either collect, process, or analyze data, and each of those vendors should be subject to strict confidentiality restrictions. And then finally, in terms of the major buckets, many times these data sets are so big, or the analysis tools that are needed are so unique that clients use cloud providers either to host the data or assist with analysis. Those counterparties likewise should be subject to confidentiality provisions. Oliver's going to talk a little later about some of the pitfalls of those contracts. But certainly because they have access to those trade secrets, the confidentiality clauses need to withstand scrutiny. I would also add that vendors like that, cloud providers, may have their own interest in using your data to do machine learning on an anonymized basis. And you want to make sure to take a close look at their rights to your data. So, for example, you have a data set that's very valuable. Because of its size and the tools that you need, you want to host it on the cloud to do your analysis. But be careful to make sure that your cloud provider hasn't granted itself its own rights to do that analysis.
Thanks, Rich. Oliver, we've heard from Rich now about the types of risk that exist when you're seeking to protect and exploit your data. How does this typically come up in practice? And what are the typical pitfalls that organizations need to look out for?
Thanks, Julian. Well, there are a number of good examples of how these pitfalls come up in transactions that businesses may enter into with third parties to either source data or store their data, or to enrich it, or to clean it up. So first of all, let's look at some of the pitfalls that lead to the loss of value in the data, or your rights or exclusivity in the data that you've created. So a good example of this is where you have got data from public sources and you have mixed that in with other data to enrich it, perhaps based on financial information you are getting. So you might have publicly sourced information about a company or about trades that are being conducted, and you might be enriching that with your own data, or possibly even with data you are sourcing from third parties. A common pitfall that exists is often in the license terms that you might have entered into to get even publicly sourced data, or to use a service with a third party that actually prohibits the redistribution of the enlarged or enriched data sets, or that limits the use in the way in which that data can be used, or may say that actually you're not permitted to rely on the data that they provide as being accurate, All of those sort of pitfalls, and you commonly see terms to that effect in public licenses and also in products that third parties might provide you with. All of those kind of pitfalls can really decrease the value that there may be in the data that you have then created and are looking to exploit. I think it's also worthwhile thinking about vendors that clients use to simply store their data, and quite often arrangements that businesses have with cloud service providers or other IT providers that host data in various systems that you might be using are good examples of this, and contracts with them have to be approached carefully, because the standard terms businesses often sign up to often include provisions that attempt to get rights to use your data or information about the way in which your data interacts with their service for their own purposes. So examples of phrases to look out for include things like, we may use the data that you provide to improve our services and for other business purposes. So that all sounds quite innocuous, but it may hide uses of data that you may not be aware of. Another example would be something like, the data that you provide us with will only be provided to provide you with support, including purposes compatible with providing that support, such as improvements to support or to the underlying services that you are obtaining. So improvement to services terms can often be given quite a wide meaning by vendors, and that may include creating new products off the benefits that they are seeing in your data or the way in which your data is interacting with their service. Another thing to bear in mind is quite often vendors that host your data will demand the right to use your data or learnings about the way in which you're interacting with their service using your data on an anonymized and aggregated basis. Now, it might seem quite innocuous. You might think, well, it's quite difficult to find any value in that from your point of view. But once they understand, once they put your data into anonymized aggregated data set, it's going to be very difficult to track how your data is then used by vendors who might end up building a similar product or providing insights to their clients using your data. So that's something that can reduce the value in it. One thing also to think about are the ways in which the third parties you interact with may use that data in terms of any onward transmission. So, for example, you may not own all of the data that you are making accessible to third parties or storing or hosting or enriching using an IT service provider, but the vendor may seek to take some sort of ownership rights to any outputs that they're creating using that data, or the way in which they repackage your data into a different form or a bigger product. That may expose you to additional legal requirements under various laws that you may not be able to warrant. Quite often there is a warranty sought from you that you will comply with all applicable laws when sourcing the data and uploading the data onto systems. Well, you may not be able to do that if it is being reused in a way that you had not envisaged. Similar pitfalls exist with customers being asked to warrant that they comply or don't breach confidentiality obligations or licensing terms when providing their data. And one final thing to think about is, how do you make sure that you maintain exclusivity around your data at the end of an arrangement? Quite often vendors you might be sharing data with, they may not return all of your data. They may claim to own some of the outputs that they create using your data, or they may give themselves irrevocable and perpetual rights to retain your data in certain purposes. All of those things may may reduce the value that you have in the data and certainly reduce the amount of exclusivity you have around how it is used.
That's it. Are you sure there's not more, Oliver? It's quite a long list of concerns and does sound rather troubling. What steps would you recommend to businesses that they take when conducting due diligence on these types of data monetization initiatives or in negotiating the contracts around them?
Well, I think there are a number of steps that business can take to protect the value in their data. I think the first thing you need to do is you need to have clear internal policies and some governance about the rights that you as a business are seeking to retain in the data that you get, and what your boundaries are with respect to how you want to use that exclusively, and what you are hoping to extract value from that data, and what you're happy to give away. So what are your crown jewels, effectively, is the question. And what are you willing to give rights to third parties with respect to that? And what are your boundaries as far as that is concerned? You need to be marking your data in accordance with a classification scheme so you can easily identify different types of data and the purposes for which it can be shared. So, crown jewels have the most restrictive data sharing rights that you're willing to give up, and less sensitive, less valuable information you can more freely give. Rights should only be given up to more sensitive data once an internal governance process has been followed and documented, so that the business is clear about what sources of data it can still extract value from and for what purposes. And in order to do that successfully, you need to know and map your legal and contractual obligations to a certain degree from an inbound data confidentiality and licensing perspective. You as a business can only give certain rights in the data that you exploit and you possibly provide to third parties if you understand what the sources of the data are, whether it's from you that you've created yourself or whether it's from third parties. And if it's from third parties, what the restrictions are around that. This helps you to formulate what you can and you can't give up in terms of the data you might be sharing or hoping to extract value from. I think you obviously need to take a look at your standard form agreements and templates when you negotiate with vendors. Can't always work from these, but to the extent you can, it offers a negotiating advantage and simplifies, the governance process of signing off any exceptions from the standard position you want to take. And I think finally, you need to conduct appropriate due diligence on the vendors and the third parties you're planning on sharing data with. Try to apply some guide rails during the negotiations to obtain favourable terms in terms of what they will be using your data for and what they won't be using your data for, and then escalate and notice any exceptions to where you would like to be as part of an internal governance process. So you have got some sort of visibility and control about where your data is, what rights you have to use it, and what rights you've given other third parties to use it.
Well, that all sounds like good advice. Rich, any closing thoughts you'd like to add to that?
Yes. So I think one thing to take away from what Oliver said is that the contractual arrangements for data are much more important than they might be for other forms of intellectual property, because there's so little default governing law to look to that you really, in the absence of legislation by the federal government or state governments or governments outside the United States, you really need to legislate yourself for the rules with respect to data and the contracts that you negotiate that touch on valuable data.
Well, thanks, Rich, and thank you, Oliver, for both of you for your insights today. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about, on anything related to technology transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.